Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Yo abusanfo Justice Atuguba, Justice Williams Atuguba emranim for anase mranim ni penyini pa ewo Ghana hanmo a meka se wakwadare wo mramu na wache ewo adwuma no so. In fact, ye ka one of the state men na say meka na say Ghana bakosem no enkrofo a omotimi ada omo ho adi na oma demonstrate so omo no omo adwuma ye mu no omo nhwe politics enye they are not partisan. Omo hwe the constitution no dia ma won so omo ndi so na omo nye. In fact, papa yi eyo obura meka na say wo President Rawlings apenso or tata na papa say President Rawlings apenso say or so far a lot of friends saying case losing ewo quarter na Justice Williams Atuguba no account and ne TV3 the key points omone no akasa na ne nkasa yemu no abusua wa kire wa da nyoma bi adi kire mu a omampanyini Akuffo Addo wa chese wa shocking to the extent that ofilise omampanyini Akuffo Addo oye mamboyfo onye obi a opese ode mra eye adwuma okrum ha o kire mu a wo Akuffo Addo asem parliamentarians asem ya abaya sa fence for vacant seats ya aba controversies ya yekeka ho asem ne ho ade wo de sa asem ni bi efa parliament ho eba Supreme Court emre bi omo de ba Supreme Court na Hackman Usu Ajman na NDC for person omu yino every parliament obra no na oye minority leader na omo de ba Supreme Court no wo omampanyina Akuffo Addo wo na wo ye Hackman Usu Ajman no ye MP at the time wo na wo ye ne lawyer na osori gina mu edi asam no emam no ka 5 panel a omo edi asam no omo squash asam no omo to asam no gu say no they can bring it to Supreme Court o kire mu a enne ne nwanwa say Supreme Court yi edi no ho for parliamentarians adwuma mu ne nwanwa say was it nano asem omkodi omo so omadi atia speaker no was it is bogus bogus agrokra no mu dey say was it total politics eno omo ye politics ade na omo ye nyina no fragadam nam ne kwan so obi dia ma obi adi into no omo ye sa adwuma no. In fact, Williams Atuguba de na me di kan no say anything na Rawlings before so be wu no or come for sa papa we can say papa you be was a Ghana ye hwe ne yie because time no ha Rawlings ni nyina no na Rawlings fi say bia Akuffo makoma nisika time aban sesai no Akuffo so started so no susu be yisu or no susu ne veto power name machinations be e dey attack this same man ejina mu yusu morality Akuffo eno na papa ndum se Rawlings ndum se papa we ye ka nkrofo a omo very patriotic no omo person omo de Ghana mra adwuma. This is the man into the man Rawlings born abaso ansa na owu no abusiafo me pese ye ko TV3 so ne kotie enkomo no se ne Williams Atuguba esitoto jabs edebo bomb mpanyini Akuffo Addo de mema Supreme Court justices because he has been there omo ho nyina omo ye the juniors wakasa kire omo se massa they should stop sa anyoma na omo te Supreme Court ho no na abusiafo yanko na ye kotie enkomo no ha PENDREAM TV message so subscribe to the channel, like the video no na share to other platforms ma omo so enya bi nhwe na ma say wa bi nkire bi afato comment section na say man ne ba be kan na ehu de also wa bi ekire ewo de wa hwe no yanko ne nkotie enkomo no embra.
You that I have a very, very important intervention and a surprise for you as well, because we needed to get to elevate this conversation in getting other minds as well on it. I've been joined on Zoom by Justice William Atuguba, retired, the former Supreme Court Justice of the Republic of Ghana. Justice William Atuguba. Good morning to you, sir, and thank you so much for joining us here on Key Point.
Morning.
And it's always good to have you. And I know that you have seen this recent ruling in this 109-page document as released by the Justices of the Supreme Court within the week on Thursday. One of the issues that has become a matter of concern is the matter of jurisdiction. The 5 justices who ruled in favor of the plaintiff, Alexa Rafenyo-Makin, is saying that even if the case was filed at the High Court and the interpretation of Article 97(1) G and H became a bone of contention, the High Court by Article 130 was required to stay proceedings and refer the issue to the Supreme Court. But in the contention of Justice Amadou Tanko, this procedure is not that which was employed in this case. And as a result of sidestepping this procedure of this High Court's jurisdiction being invoked on this case, but rather going directly to the Supreme Court, it negates the Supreme Court's jurisdiction on this particular case. I want to find out your thoughts on this matter of jurisdiction, whether it has been settled, really, by the recent ruling.
Thank you. This question of jurisdiction ought to have been regarded as settled long ago if the court was minded to follow precedent. Well, the court is bound by its previous decisions. It can depart from them for good reason. But there came a time this provision about stare decisis has virtually been negated. You'll find in the latter days, and take it from, let's say, 2012, thereabouts going, you find there's complete and frequent violation of that rule of stare decisis. The question about the jurisdiction in this matter, I mean, it could not have been a serious problem if these stare decisis were observed. First of all, even let's ask a very common sense question. When parliamentary results are declared and people are contending that they rather should have been elected, the results were not fair, where do they go? Is that to the High Court? And who has ever said that that's the wrong forum? Common sense. And this common sense is supported by the provisions of the Constitution. Otherwise, how could it have been happening? Unchallenged. But suddenly, beginning from, I think, the Beer Bell case, second day, Amadou and Beer Bell versus second. No, he rather even went a second day. Here was a case that concerned the validity of the election of the MP for Boku Central, I think. The challenge to his election went to the High Court. It was thrown out while it was out of time. It went to the Court of Appeal, and they failed there. And then a new action was brought to the Supreme Court. This same situation arose, I think, in 1997 or so, in the case of Yeboah versus J.H. Mensah. I was on that panel. Let's briefly state the facts. J.H. Mensah, I think it was from Sunyani or so. He didn't contest that particular election from where he hailed from. That's Sunyani. He went to another place, and he did not reside there for a continuous period or an aggregate of 5 years, as required by the Constitution. And actually, if the plaintiffs had taken that matter up in the High Court within the 21 days, he would have been thrown out of Parliament. Because he clearly could not satisfy. But they waited until that period had expired. And now, and that's where I want always to be forthright. This man turned out to be a problem to the government of the day in Parliament as minority leader. And I think some felt that should be a way to get him out. They then found that the High Court gate was closed, so they sought to circumvent that by coming to the Supreme Court. I was on the panel. And the issue. Now, interestingly enough, it was this same president who was counsel for J.H. Mensah. And he contended that the Supreme Court had no jurisdiction. It was a parliamentary matter. Now, we're confronted with the previous decision of Wedima versus Awana Williams. That was decided in 1969 by judges one dares not to disagree with. But that is beside the point. When this matter came before me, I must confess, I was suspicious. Why is it that after all this time they are coming with this matter? Is it because the man is a pain in somebody's flesh? So I said to myself, if I look at this matter and I find that, there's no jurisdiction, I'll throw the case out. That was my approach. So I read that Wedima versus Awana Williams.
Yes.
And Azu Crab, who read the judgment, who wrote it, said that on the issue of parliamentary election, the Supreme Court and the High Court had concurrent jurisdiction. So I had to consider this man over and over and over as a pure legal question, not question of politics as we are doing today. And I found that notwithstanding their distinguished judicial status, I couldn't agree with them that when the Constitution says in Article 130 that subject to the High Court jurisdiction of fundamental human rights, the Supreme Court shall have exclusive jurisdiction with regard to interpretation and enforcement. It can at the same time, how can something be exclusive and be concurrent at the same time? So when I got to that idea, I said, no, I will not accept their reasoning. And that found me to rule in favor of J.H. Mensah. We're 5 on the panel, only 1 dissented. We took time wrote lengthy judgment and analyzed. When BLBL case came, the lead judgment didn't, as far as I can recall, didn't deal with that, didn't try to see whether we're right in departing from Williams and Goodman. Nothing. Just said that, each time that the person continued to sit in the Supreme Court, in the Parliament, was a new course of action. Now, I don't see this in it, because there's one provision governing the status of the elected person. And right. In my opinion, that makes it an action in rem. It relates to the status of the elected person. Not an action in so that accrual of course of action keeps on. And even if it is, the express limitation period is there. So, we departed from our Williams and clearly established that in matters of parliamentary tenure, election, validity of elections and so forth, the High Court is a proper forum.
The High Court is the proper forum?
Yes. For the determination of the validity of a parliamentary election. And of course, by extension, that's just one item of that jurisdiction. If there are others, also like vacation, it simply follows common sense, common logic, that the same thing will apply.
So in that sense, the Supreme Court shouldn't have even entertained this particular case at all?
At all. Now let me emphasize. The jurisdiction to interpret and to enforce under Article 130 is described as an original jurisdiction. I'm saying that in a situation like this, they don't have original jurisdiction. What they have is a jurisdiction of reference. The subject matter belongs to the High Court. And the same Article 132 makes it clear that in a situation like that, they have only reference jurisdiction. So I don't see, I don't know. That's why I'm emphasizing. And I think that at the heart of all this pretentious discussion going on, there's no true legality involved. It's just politics. That honorable type. All we are doing is the paramountcy of political partisanship. Partisanship. That is what is controlling this country. If that is not addressed, we are just wasting our time. True law no longer will apply. Where the basis of anything in this country is political, politically driven. That is the menace. I agree with Martin Kwebu's observations along these lines. That is a fundamental matter. Unless it's arrested, this menace, this vice will continue to fester, and constitutionalism will be subverted, paid lip service to, people suffer. In other words, we are not entitled to benefit from the constitutional order put in place for this country. That is the true situation. That's the true evil to be addressed.
When you make reference to the fact that clearly the Supreme Court shouldn't have entertained this case at all, in the recent ruling of the 5 who ruled in favor of the plaintiff, they argue that although the High Court had jurisdiction with regard to whether a seat is vacant or not in Parliament, what was before them was purely a question of law regarding the true interpretation of 97(1)(g) and (h), and not factual disputes regarding seat vacation in Parliament.
Sorry to say that's superficial reasoning.
That's superficial reasoning.
Yes. It is not, but that issue has been addressed by Article 132, that where it arises in a matter belonging to another court, the Supreme Court only comes in when an interpretation or enforcement issue arises and is referred to the Supreme Court. That is the only time they can come in. So you don't, take 132 about is it not dealing specifically with that question of law that they are talking of and how it should be, brought to the Supreme Court?
Indeed, 132 says where an issue that relates to a matter or question referred to in clause 1 of this article arises in any proceedings in the court other than the Supreme Court, the court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
Yes, that is the constitutional order. And let me say this, those days that law was, there was fidelity to the law, and even today is reflected in their judgment, the majority judgment. Jurisdiction is a fundamental matter. So the conditions upon which your jurisdiction arises, if they are not there, you don't have the jurisdiction. And that is it. Now this matter is directed to the High Court. However patent the constitutional issue that may arise there, you don't have original jurisdiction, you have jurisdiction of reference. That is it. Is that what they exercised? That's not what they exercised. They purported to exercise original jurisdiction, whereas in this kind of situation, it is only reference jurisdiction. It's quite clear from the same provisions of 130.
So as the Supreme Court has always held consistently, a point of jurisdiction, when taken and successfully upheld, should foreclose any consideration of the merits of any case.
Completely. You don't have jurisdiction, how do you touch the merits? And even in the majority, there is clearly and plenarily stated therein, and I agree with that. Even they are saying as is solidly laid down that as for jurisdiction is so fundamental that even if the parties don't raise it, the court itself suo motu ex debito justitia.
So it sounds like there will be no foundation upon which the merits can stand.
At all. How can you put something on Mafua and UAC? Mosi and Bajina? Mafua and UAC, I think it's something, but as for Mosi and Bajina, I think it's 1963, volume 1, Ghana Law Report, page 634 or so. Supreme Court. Akuffo Addo wrote that unanimous judgment. So, you don't say that, the same issue would have come. The thing is, when do you have jurisdiction over the issue in a matter that is consigned to a lower court? That is it. No, you don't substitute the desiderata for, actuality of jurisdiction. Supreme Court.
Well, Justice Amado makes the point and said that to the extent that this matter of jurisdiction is a problem, Justice Amado says that he finds the decision of the majority as an aberration to the established and accepted judicial position of the Supreme Court, which, with profound respect, he says he hopes in no distant future the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed. You agree with that?
Well, yes, but the thing is, as I've told you, in the course of time, the Supreme Court was not faithful to the constitutional prescription of stare decisis. So you find Biabel and Sakande going off tangent, entertaining a matter that should have been commenced in the High Court, and then some followed. It's very interesting. If you read that Biabel case, and look, the Doche and another justice, that's interesting, eh? They disagreed with the majority decision on the grounds that I'm canvassing. The same grounds. That's very interesting. You know, I think when we, in human life, it's important to apply realism and that things. That very significant that happened. The majority decision didn't even discuss, if I remember well, I'm yet to go back to my books. It's 6 years since I've referred, but I think recollecting.
Indeed.
They did not examine Awana Williams and Grediman. They did not examine Yeboah and Mensah and so forth, and try to demonstrate why those decisions should not bind them. That is, from a certain time, the Supreme Court, after you started sliding down Judicial. I'm telling you, you find that this stare decisis was not observed. You find a panel taking a decision one way, then another case comes. Either the same panel or a good number of those who decided will take a contrary stand, and then back and, I mean, this wasn't happening before. That's why I'm saying something fundamentally has gone wrong. That is what has to be redressed. If we are to get back on track and run this country properly and not politically and myopically. Now,
sir, and you think that politics is a cause of this, that the judiciary could continuously been drawn into politics? Because that was a concern by many, that this case may have just overly exposed the judiciary to the politics of it, sir.
Yes, you said?
Sorry, I lost you briefly then. You were talking about the problem that we have, the problem that we are faced with now. And yes, the concern that was raised when this matter started was that this was going to open up the judiciary for the politics of this particular issue. And do you see that as a problem here?
It's a problem. That's a realistic problem. Now I'll demonstrate it. Look even at the empanelment. Who has referred to all those? I mean, for what reason will you bring the younger justices to handle such a weighty matter to the exclusion of the seniors? What reason? I mean, this reason, sir. Then they brought in these two others, but I mean, what were they going to do? In fact, even legally, I don't see whatever was left for them to decide on this, because in rejecting the application to set aside their injunction, one or their directive, they had ruled that they had jurisdiction. They had already decided that they had jurisdiction. The speaker had no jurisdiction over the matter. It was so. What was left actually for determination? And so, and these same 5 who ruled that there was jurisdiction, they were still there, and only 2 came, and the 5 went the way they went, predictably.
So it was predictable?
Oh, sure. Are you not in this? Don't you follow the horizon of judicial functioning in the Supreme Court? Are you surprised? Tell me honestly, were you surprised?
The way that the 5 justices went on the particular case was predictable.
And let me tell you, why wasn't it even, let us even go by pretentious legal theory. They're not the same person who had ruled on the the application to set aside their processes, that they had jurisdiction. And so, I mean, if the same people are to pronounce again on the same matter,
Okay.
don't you see
Yes, indeed. It was the 5 who sat on the speaker's application. Yes. So the dissenting 2 were only added on the substantive case.
Yes. Now what could 2 do against 5? Look, as I've said some time ago, this question of political poison in the judicial system didn't start today, but it has gotten to, its peak under this current administration. It has gotten to its peak. And that is the real virus, constitutional virus, to be redressed. You find the lawyers coming to the studios, they are not coming there really to talk about lawyers, except a few of them. Some like Atuguba, I don't think is politically minded from his presentations. But some just come, their duty is to uphold their party's line. They're not interested in the correct law, but their party position must prevail. That's what's happening. And so, that's the fundamental thing to otherwise this kind of thing will continue under the guise of legality and constitutionalism, under the guise.
What's the danger that we're faced with with this situation, as you have so passionately spoken about, if what you have just espoused continues?
You said, what is the way forward?
Yes. In fact, the danger we are confronted with the politicization of the judicial process, as you put it there. What is the danger that we are faced with if this continues? That's what I was asking.
Oh, it will be continuing in the rule of people, rule of politics, not of law. Clearly, not rule of politics, political partisanship. That's what is obtaining. And if it's not arrested, no matter which party comes, we'll continue suffering. That's why I'm so concerned.
And continuously...
Pardon?
Yes, you were making a point. Sorry. You went silent a bit. Yes. But you can go ahead.
Oh, you have jurisdiction over the matter to ask the question.
Indeed, I have original jurisdiction on this program. Not a reference jurisdiction. Indeed, so
yes,
exclusive jurisdiction, indeed.
Not concurrent.
Not at all.
Not at all. I'm scandalized to see in the reference of some of the majority judgments that on an issue where the Supreme Court
It's unfortunate. We're having a this.
And the High Court have concurrent jurisdiction on the matter. The concurrent jurisdiction of kind of concurrence. There's no concurrence there. It says it's exclusive, and I cannot reason by any process to arrive at the fact that when they say something is exclusive, it can also be capable of concurrence with another person.
But
my mind cannot have.
And the other justification by the majority justice, Justice Akuffo Addo, wrote that it must be placed on record here and now that there is no provision in the Constitution that when a person perceives that a provision of the Constitution requires the interpretation or the enforcement of this court, or that when it is perceived that a legislation has been made in excess of the powers conferred on Parliament, that person shall first have to institute a suit in the High Court before the High Court could refer the matter to the Supreme Court. Such a stand will be very, in his view, circuitous indeed. Any such condition imposed on Ghanaians is, in his view, with the greatest respect, not sanctioned by the Constitution.
Oh, with all due respect to him, you know, the legal legs is standing on for this kind of denunciation. Is anybody seriously saying that where a matter, a cause or matter, is within the original jurisdiction of another court and only referential jurisdiction is reserved to the Supreme Court can still purport to have original jurisdiction? And where is concurrence? I mean, the scenario he has even painted doesn't arise. Because you are bound to go there and then referentially come to a Supreme Court. And let me say this. Politics apart. Long ago, it's not today, Mekankai and the Republic, Asiama and so, look, long ago, yes, and from Awana Williams and Wedima, if a matter is not ambiguous, any court can apply the Constitution. In that case, interpretation doesn't arise. These days, and from the way things are going, you can give the dog a bad name and hang it. Something can be crystal clear. Oh, it's not clear. Look, man, these are the things. Now let me tell you, this situation has to be arrested seriously for constitutional governance and not political, partisanship functioning. That's not governance. It takes place. One, the mode of appointment of judges suffers from the virus of hepatitis infection. That's even gone cirrhosis.
The judge has become doctor.
Sir?
Why do you want to establish an independent judicial and the president is the appointing? And even if you look at the appointment, he specifically has the power to nominate and appoint the Chief Justice, who is the head.
Sir, fortunately, we
want an institution to be independent, yes, and the head must be yours. No, that's nonsense. That's to use the old party expression, malice aforethought. The pain of the constitutional deterioration in this country. I say there has been massive constitutional deterioration.
Sir, I do appreciate your time and pouring out your heart on this matter.
Is it possible
Justice William Atuguba, retired.
Abusiafo bia enkomo no ekosie na yede abramo no asam no ani ayinyan abusuafo woma yenka no kre ba bia oman no omanpanyin Akuffo Addo de adu no ewa hwe ba bia adu no it is only change of government and it to me assign a day a year on my gun as I be see papa no hayu ulumano or nene baumiano mahaye big time a serious in fact wa higher chain Rollins. I'm telling you wa higher baby o dia duru no and kama Rollins mpo na nya saa nyoma ni bi nanka yenka so Rollins there or yesu jani nti no yesa no mra no mfa nya adwuma kama Rollins nye but no na Justice Atuguba Ekano. So even under Rollins 1997, he stood against them and threw out their case when they were after a friend saying Hakmon Usu Ajma, a friend said what J.H. Mensah, when they were after him. He stood against them, would throw as I'm not touching here. Rollins and Kasa. What's he say? Because he believed in the rule of law. Biano ye soja nimpo. Na saa no papa we a ne wa betena so yefe na Akuffo Addo yi aye demonstrations atia Rollins amanipa kra in the name of human rights lawyer. Ono a human rights lawyer. He believes in the rule of law. And ne such a person na betena bam hwe de ode mra Asai Ghana mra watu Ghana mra no atu babi no de ne pe ono a planting nkrofo ho e no de ne pe so onu asema Atuguba say the 5 people no cry dey omo betena asam no kwa was wrong because there are senior most judges who honum no washeda kofa young boys ya yakofa from 2016 2017 2018 2019 e dey omo ba Supreme Court no waka say case of this sort the any kwansi this ankwala no nebeto so you will senior most lawyers judges justices or in the Supreme Court or mono or matena say akasa hansem we bi dane ho ade or mo na wase ye mo betena sa case so no akofa nipa 5 young boys including MPP FNC candidate 2016 who central or no so ti asem no so bi na odi ma ba oh say nipa 2 na omo ba ye na no mu ye offense senior judges justices Supreme Court nipa 2 no so omo na be dissent ye no omo and be chire say no speaker of parliament right for sacking them sa nipa 2 no me seniors no waka no nipa 2 na later odi omo be ka ho mo ye 7 no sa 2 na be ka no ye seniors omo Supreme Court ho no we mu betoto omo no omo na dissent ye say there be ne speaker kan no ne kwan so ano e che say we mu na Akuffo Addo boys a wodi omo abehye honum including chief justice no omo na Akuffo Addo ne boys ne girls ne boys a ono ankasa plant omo yi omo akwhye honum say do my bidding mo no me tua mo ka forget about the law mo nye de me pe emma me e no mo tuo no mo ye bisafo no kan say yanhwe na yanhwe na yanya hu bibi o say arrest this offense this situation else o ka say arrest this situation say yam put a stop to it and you can nyina say this government must be sacked your person o chire nyina. How can we arrest it if these people are still in power? We can never do anything about it if these people are still in power. Papa no nyansa kasakwan no ka kire you know. Excuse me. Kasakwan no ka kire no. The only way and the only time we beat me so sad we are no and say be pamon. Na ye be ye bibia for constitution because Akuffo no madie bone ade a wonim say enye mra na ka to plain Say as somewhere parliament issue there, you didn't know high court. In new kwanza wuna wudi. That's a high court di asem say there is an issue of interpretation. Nti ase bi nu na high court a refer the ama Supreme Court. Na wa chiri na say aba Supreme Court na omo e de aye adwuma. Asem no nyanko high court. Supreme Court say makoka substantive offense and case no maka wi abra high court enkodi asese kai call high court and high court say yentumi ana asem no emu asem emu no like issue na ewo mu no dintin yen refer nko a eno na nka obeka kire me say high court for na dia abra o ma refer dia abra no Chief Justice offense Justice Atuguba kano senka high court na refer brewa perfect because omuna constitution this are 2 million the amount so omun chere asem no and also omundi parliament any parliamentary issue be ebeba no ho ne yedi no it is a bibi nkosu ya na nke arefe na parliament high court refer bibi anfa mbrɛ ye mfa asem bi anko high court o se mete ho me de maka ne maka ma dim asem abra issue non call baby those who have the jurisdiction was omo na ehye omo disasem no enko ho mpo se me de maka. Can you imagine we yekoya na e ba ebusianfo we yekoye ana e ba e asemo ya mepe ene betimi ahu ye mobo no wagye efiri sa enkofo yinsam. I'm telling you nya mepe yes nya mepe the moment ye ni mere ni hwe kwan ye bitumi afa so apam nkrofo afiri eye office abusianfo eye enkomo a ye kofa free TV3 the key points Jima die no no ena ye kofa enkomo twetwe a course so ewo TV3 wo brana omone eye Justice Williams Atuguba twetwe enkomo. These are some of the people we need in our county. Ombeka no kran said the we were standing in one president FNC Achampo mu nyina dia face so ne Rollins dia be face so abi wura president Akuffo Addo so one ne de face so president Tamils John Mahama no oye non-partisan. That is why Rollins had to FNC like FNC commenting and son of Rollins born abaso and son of papa Rollins you what you say o ye no kwadifo on famra iniagro obusan wa adwenchire bi afato comment section no asema na subscribe to the channel no like video no emaye na share to other platforms na entumi enko achire my PENDREAM TV say edam yopo
Dedi kama amena PENDREAM TV ase na so far so good say open online portal e wo Ghana nipa share nipa follow nipa comment here to my best of knowledge without any biases PENDREAM TV